So I have started the recording, so if you share something, it could be visible, although I'm tend nowadays to putting everything in YouTube, so typically then they can't see the chat. But any comments you'd like to make about how things are going with you folks right now? What are you doing for hobbies? What state are you in? I'm in Minnesota, doing some golf here and there. Say something about yourself in the chat, please, if you can. All right. How old? How old is your son? Oh, wow. Okay. So, so are they doing mental math? I remember a few years ago, I was mentoring a young child, and no, we're just kind of getting to know one another a little bit here. I was trying to mentor, and actually, what was it? Fifth grade, and was it fifth grade math or sixth grade math? I think, yeah, the one that I think it was sixth grade math, and that was not easy. They were doing their math in a completely different way, and they changed it again, so to speak. They changed it when I was a kid, and I actually helped teach the class when I was in sixth grade. I helped teach math. I remember that because the teacher, we had a teacher for sixth grade that if she had been a high school teacher, she would have been a great English teacher, but she was not a math person. So a couple of us that liked math a lot helped teach because they dumped a new math method on her in August while she was on vacation, and then she arrives kind of cold in class. We're going to talk a little bit about negligence, the reasonable person concept, res ipsa loquitur. Res ipsa loquitur is a strange thing, but there's a water bucket up on the top step, and there's a flow of water down here. And let's say that this is not entirely water; it's dirty water, and about half of it's left. You find a little puddle down here, and water all the way down. Res ipsa says that the thing itself speaks. Res is thing. Itself speaks. Loquitur is like loquacious or something, which is talking. Somebody who talks a lot is loquacious. And res is a thing. Oh, I hope you don't think I really know Latin, but I know some legal Latin. But anyway, the thing itself speaks. If you were on a jury and somebody says, well, was the dirty water from that bucket, you would say, the thing speaks. Okay? The fact that there's a partially empty bucket of dirty water here and dirty water all the way down, it was probably that bucket that dumped the water. It probably was not somebody bringing a hose from 2 blocks away that sprayed down there. Do you see what I'm talking about? If somebody falls off a ladder and then breaks a leg, they're at the bottom. They're on the ground. The person's on the ground, and there's a ladder also on the ground, damage to the siding. You would kind of surmise that the person fell off the ladder when the ladder collapsed or the ladder fell, and that's how they broke their leg. Now, it's not absolute proof, but it's the things that you're seeing itself are speaking. Overview of torts. Three types of torts. intentional. Okay, and I want you to take a look at what folks are. Yeah. Oh, thank you for introducing yourselves in the chat. And I also want you to do so with the other classmates in the discussion forum, the student lounge forum, if that's okay. It doesn't take long. You can say the same things you're saying here, but kind of try to get people going. If the class feels more like a class, it seems like everybody does better. People sort of feel accountable when you have a discussion forum, for instance. They sort of feel like they want to help by providing sources. And then, of course, they get points. They get personal points, but they also help others. So you go with three bases of torts: intentional torts, negligence, strict liability. Which one do you think sounds more like a crime? In fact, it may also be a crime. Yeah. Frequently also a crime. But you want to draw a bright line, though, between intentional and crime, because even though they're deceptively similar, they're different. So remember, crime and punishment, torts and dollars exchange hands, okay? Equal, go for dollars. Crime and punishment, okay? Now, negligence can also be a crime. What's an example would be careless driving. Now, it may not be called that in your state. Your state may have negligent driving or reckless driving. My state traditionally has had both careless driving and reckless driving, reckless being worse than careless. But careless driving, frankly, almost everyone has committed it. But if you didn't get in a crash or you didn't go off the road, you probably didn't get charged with it. Or if you didn't go over the center line and make somebody else swerve, you maybe never got charged with it. But you didn't try to do anything wrong, you just messed up, and yes, that can be a crime. Strict liability, best way to stay away from strict liability from being sued for it is don't become a fireworks maker, okay? Or sell them. And don't do ultra-hazardous things, and you won't be strictly liable typically, okay? Now, basically, if you get involved in strict liability, that means some company usually, or some business is being treated almost like they're insuring the situation, as opposed to them just trying to avoid being careless. If we represent a client that is subject to strict liability, we want them to put fences around things, we'd want them to obey lots of rules and regulations, like have fire doors, and if they're doing welding in there in the business, you want to have you want them to have a specially produced building that allows them to weld safely, because they're kind of stuck with strict liability. The same thing with a lot of things, I guess, a bunch of things, put it that way. There's strict liability. It's hard to defeat. Unfortunately, well, unfortunately, no. Actually, uh, the ticket says that you assumed the risk, unfortunately. So they're probably not going to get nailed for strict liability. Um, the risk if you bungee jump. I don't know about amusement parks. You assume the risk, and we'll talk about that later. One of the things, though, in this course, as in others, is you have a right to be partially wrong as long as you're exploring sources. As long as you were exploring different ways to analyze the topic in different sources, being partially wrong is not probably going to be a problem. Just keep advancing. So you say, well, I used the text for this, and then I used this, or I used this source. Just keep plugging along. There's an imperfect system of compensation. Unfortunately, there are lawyers and paralegals that are paid for delay. And I hope you say, Kirk, you're biased. You weren't on their side. You didn't represent, you didn't work with insurance companies, so you are biased. Correct. I am biased. Therefore, you can find an exception to what I say and get points for it. Therefore, you should be able to find some ways in which I am partially wrong, or if I'm not wrong, there are exceptions to what I say. There are many cases where the insurance company would just like to resolve it, and maybe somebody else is delaying it. But lawyers and paralegals do get paid for delay. One of the reasons one of the reasons nobody ever called me and said we'd like you to be a judge, at least no attorneys ever did, is they know that I would crack down and delay, and I would be after them like every day. You know, I'd be I guess I wouldn't be calling them, but because judges can't call them, but I would basically be sending some nasty notes to the lawyers saying, either handle the case or turn it over to somebody else. You can't delay just because you got other cases. Everybody has other cases. if a person is working for insurance companies, defendants, basically working for the defendant and the insurance company, or working for the plaintiff, they really have no excuse for constant delays because they were not forced to take that case. It's not like being a prosecutor or defense attorney that is forced to take 100 cases. You know, you either have to quit your job or take these 100 cases. I understand, you know, like public defense or prosecution, you're stuck. But hey, Mr. or Mrs. Lawyer, you could have turned that case down. If you don't have time for it, turn it over to somebody else. Playing the delay game is not good, but not enough judges put the kibosh to it. So, and I'm partially wrong about that too, because they do have new systems in place to try to stop the delayers. I'm a skeptic about that. I'm a skeptic about whether they're going to enforce them. But there's a lot of things in place. If you want to be a delay fighter, there's now ways to fight that. But you have to fight it hard. You can't assume that things are going to go forward, okay? Pretrial, trial, appeal. But there's also the before pretrial. Well, I think we mean pretrial writ large. So you see the client comes in, evaluate first, and then of course there's legal papers called pleadings, right? Have you guys had civil litigation already? I don't know that I would have ever been a great judge, frankly, because I handled different sides of child protection cases, and in my state, every judge does everything, and I'm afraid I would have got a little too emotional. Plus, I think the best judges can read faces really well, and they have maybe a better idea of who's lying than I do. So I'm not being falsely modest either. I admire judges. I do think they're too easy on delayers, but I admire their wondrous way of both disguising their own disguising their own faces and what they're thinking about a case, and somehow seeing other people's faces and getting a pretty good idea of who's being straight with them. I really admire judges who are good at that, and a bunch of them are. What's a good example of a duty that's pretty basic that a lot of people have experience with would be to drive safely according to the rules of the road. How's that? Fair enough? Yeah. Can I give you an example from my own town, and one that a large amount of people do? How many of you have, I mean, other than during this COVID thing, have driven your kids back and forth to school? Okay, you go off, this is the highway from Long Prairie, Minnesota to Little Falls, Minnesota, okay? And if you are in the red lane here, I don't know if I can do that, yeah. And then here's the intersection. This road goes to the school, okay? The school is that way. This drives me nuts. If you are going away from the school and you want to take a right turn, and there's nothing coming from this direction, you should be able to take a right turn, shouldn't you? But you can't, because these people want to go this way. I don't get it. What gives them the idea that they can do that? This is not their lane. The people going to school, you don't have a right to cut across that way. But that's per se negligence because the rules of the road say that if you want to go that way, you have to go this way. You see what I'm saying? Any questions? I mean, it's not rocket science. But this happens over and over, and all I want to do is go down to the fairgrounds or something like that, or the school, and I want to go this way. And you have to, there's no stop sign here. You have to basically stop because there's a whole line of cars cutting across. Yeah. Well, but so they breach duty. Now, because of my experience in the law office, though, I assume others will breach duty. So don't buck the informal system either. Don't buck the system, but if everybody's going to do that, sort of reminds me of the Karate Kid. Don't be there. So when people are cutting the corner, don't be there. Be somewhere else. So I guess I don't head in that direction when there's a line of cars there because they're all going to cut the corner. Disobey. If they do, they breach the duty. Actual cause. Actual cause is pretty simple in a way. It's complicated in practice, but it would be the logical main cause of the problem. Okay, but proximate cause, that's going to take some explanation. Example, that would be that is a rule of law not reasonably they were not reasonably able to foresee that their actions would cause harm. Okay. So there has to be some limit to the idea of cause. If you upset one of those drivers who cuts the corners 2 hours before, that might have been a partial cause of them causing the problem, but your liability is going to be ignored because it was not proximate or close by to it, and it was not reasonably to be anticipated that you're emotionally upsetting that person is going to cause them to run into another driver. But then there has to be some kind of a harm to either person or property, harm to other car or personal injury. Yeah, Angie has a good example of different kinds of negligence that we've all seen. And written assignment. I want to take a look at it maybe. Let's see if we can see it. Can you see it? Okay. Thomas Jones fell on a wet floor at Al's Groceries. So you want to go to slip and fall cases. You can do more questions. It says at least 10. Don't do 20, but you may do more than 10 if you are worried that your questions are not wonderful. I'm going to say that I absolutely do not want you to ask any yes or no. If it could possibly be answered yes, no, do not ask it. Subparts. I guess do your best to answer, to ask the questions that are somewhat basic, but I'd rather have you draft your own questions. Even if you don't think they're that wonderful. Better educationally by far. Don't use someone else's. I don't know if it's Samantha I suspect that your subparts would work, but I would try to do 10. But ask the obvious questions and the generalized ones, okay? Generalized ones. 0, yes or no. Can I tell you a story about my mother-in-law? And I probably was a little bit mean, which I feel bad about. Wonderful, wonderful woman, but she could not ask a question except for a yes/no question. She couldn't. So don't in this particular instance, don't be like her, okay? She was a wonderful person, but she would ask me something like, did you play 9 holes of golf? Did you play 9 holes of golf with your friend John? What was the answer? The answer to all of her questions, if I had actually answered them, which I frequently did, was I just said no. Well, I was wearing my golfing hat. I had put my golf clubs away, and she would look puzzled. She expected me to not answer her question, but to answer the question that she should have asked. She should have asked me, hey, where'd you go? What'd you do? And then I would have said, I went to the golf driving range. And I didn't actually play golf. I just hit golf balls. But she always asked a yes/no question. Good question here in the chat. All you have to do is ask 10 questions. So I don't know that you'd even have to do research, but the whole process will make more sense to you if you do. Okay? So how about this question? Let's see, which site are we on? Oh, we're helping Thomas. Okay. So I asked the question, did you have water or anything else slippery on the floor? Is that an acceptable interrogatory? In my view, in Kirk's view, no. Okay. How about describe? This one is tricky because this is not a question. Condition of the floor, whatever. That doesn't seem to be a question, but it works even though it's a statement. It's a request. A request for information is okay in my book. A lot of people think that you have to ask a preliminary yes/no question before you ask one. No, you don't. And I will let you ask questions like, please describe all insurance coverages that you have. I will not permit you to ask, do you have insurance? Because if you ask them, do you have insurance, then you would have to have another follow-up question saying, what insurance do you have? Do you see where I'm coming from? I think there's a mistake in both the legal and the paralegal world that they think you have to ask these preliminary questions and you don't. Do not have to ask them. If the answer is we have no insurance, you didn't have to preliminarily ask them whether they had it. You could just ask them to describe all insurance policies that they have on the building that may cover slip and fall. There's no reason you have to ask a preliminary question. There is another type of legal document that lawyers work on. Lawyers don't seem to know enough about it. It's called the request for admissions, and that's something different. We're not going to do that this time. Again, what I say has exceptions within the legal world. When I say never ask this question yes or no, the big exception, it's a huge exception, big enough to drive a truck through. We're just not doing it this time. The big exception is, yes, there are requests for admission. They're not called interrogatories. They aren't part of this document, but they exist and they do help. We're just not doing them this week. Any questions about that? Lawyers actually underuse requests for admissions, and there's some reasons for it, some good reasons, some bad reasons. But interrogatories, sometimes lawyers do not ask the obvious questions. Master the obvious before you get to the subtle. Go ahead. Master the obvious. Correct. I do not need a cover page and a reference page. For this assignment. This is also the only thing I really want in terms of I really don't even want a lot of references at all on this one because I just want your own questions more so than anything. But if you borrow somebody else's questions, cite it using Blue Book. But then that one doesn't count as one of the 10. Then do 10 of your own, okay? Let me look in the syllabus. What are you talking about in the syllabus? Oh, APA? Oh, Arial font? Oh. Go, you may do that. You may use it. I'm not going to grade on using Arial font. But it's fine. I appreciate that. That's a good thing to look for. But I'm not going to grade on it. Okay. Yeah, just not going to. But go ahead and master the obvious. Then you can ask particular questions. And you can ask in your own words. Ask what happened questions, okay? What are the so-called journalist friends that are also the friends of paralegals in terms of interrogatories? Who, what, when, where, how, and sometimes why. I think you can get 10 questions out of those, don't you think? So I would start with the very general and then some particular questions about slip and fall. And of course, do you get to ask about witnesses? Are you going to ask a question like, are there any witnesses? Do you have to ask that before you can ask particulars about, ask them to tell about the witnesses? Or can we go right to asking them for a list? Yeah, we don't need to ask that. We can, in your own words, ask them to report on witnesses, all witnesses. But I want you to do the more you put it in your own words, the more I think that you are going to be thinking through how the case works. You can imagine what they may answer and how they may describe it, but are there penalties for not answering the questions thoroughly, do you think? Assume you have a really good judge, and most judges are really good judges. Aside from what I said about them not cracking down on delay, some of them do a wonderful job, and they all, I think, do a pretty good job of fairness to both sides and trying to get people to tell the truth. Let's say that you asked a good who question, and they left out a couple of names that come up later. They knew those names, but they didn't give them. What do you think the judge is going to do later on in the case? My wife heard that, and she says whatever the judge wants to do. But well, it's not probably going to be obstruction of justice, but it's going to be a penalty, a civil penalty, making it harder for them to win the case. My wife is a former social worker, so you've got to understand she thinks judges can do whatever judges want to do. It was in her little rule book. But civil penalty, let's say that they have a couple witnesses they didn't tell us about because maybe we didn't ask the question quite as perfect as we should have and they tried to evade it. Well, they're not witnesses because we're not going to call them in court. You should have asked us for anybody that had information or perceived anything, whether they heard it, saw it, or smelled it, or anything, you know. Well, the judge is probably going to, when they try to call those witnesses in court, the judge is probably going to say, you didn't disclose those, you can't call them. You see where I'm coming from? And then all of a sudden, oh, my lawyer can't call these witnesses because he didn't disclose them or she didn't disclose them. What kind of a lawyer is that? Well, hey, when the lawyer was telling you how tough the lawyer was and that they were not going to cooperate too much with those bad guys on the other side, you thought it was great. But now you're going to lose because, yeah. No, Samantha, you may do that, but you're not required to. Yeah, she was talking about some ways to do interrogatories that are always done in standard forms and stuff. What I'm really looking at is for you to come up with who, what, when, where, how, and sometimes why questions about the case. We don't know much yet. Typically, we would know somewhat more than we do before we ask, but you come up with these questions and you will try to, as you do it and after you do it, you're going to think about how they might try to evade it. But I'm just trying to reassure people that if the other side evades them because of silly reasons, they are the ones that need to worry a little bit. A good judge is going to crack down on them like nobody's business, okay? So you go ahead and boldly create your own questions, open-ended questions that could not possibly be answered yes or no, or basically requests for information that don't look like that they're not actually an English language question. They don't call for a question mark, but you ask them to describe something, list some things. The same thing is you don't have to ask them if they have documents, for instance. When we get to documents in a case, you don't have to ask if they have them, just ask them to produce them. When you ask for anybody that has information, whether you want to call them witnesses or whatever, you don't have to say, were there any other witnesses? You can just ask them for a list, and it's up to you to decide how much you want to ask. Do you want to ask for names, addresses, phone numbers? If they don't have something, then it's their obligation to just say, the answer is none, we don't have any. If you want to know what their procedure is for slippery floors, you can ask that. Instead of saying, do you have a procedure to safeguard people from slippery floors, you don't have to ask if they have it. You just ask, what are your procedures to safeguard customers? Does that make sense? People assume that if you don't ask yes, no questions, that they'll just wiggle out of all of them. But I would dare to, they're going to have trouble if they have anywhere near of a normal type judge is going to slam them pretty bad if they don't answer them. Okay, if they don't answer them fairly and fully, because that's our system. Our current system doesn't allow them to surprise us and say, "Oh, you know, you misspelled L's groceries. You left off the apostrophe or something. You know, there's an apostrophe in L's groceries in your question, and so you must have been talking about the L's groceries in another state. So I won't answer it. Good luck. The judge is gonna. You see where I'm coming from? Now, the lawyer you work for will have forms and typical questions that they have. But as you have had to do some of your own, you will be able to help repair some of those questions and to make them better. And then when you have an unusual case, you will be able to draft some from scratch, because it's not always going to be auto accident and slip and fall. You know, sometimes it's going to be failure to provide insurance coverage for health insurance, you know, employer health insurance coverage, and there's no forms for that. And sale of seeds that do not germinate, and you see where I'm coming from? Or sale of seeds with, this one has never come up to my knowledge, but sale of seeds that have an unlabeled pesticide on them that should not have been sold to somebody who is trying to farm organically. How's that? Well, there are points for, later on in the course, there will be points for Blue Book citations. You can earn points for doing Blue Book citations later on in the course and in the discussion, you know. It's just that because of the grading 4 sections, I will not catch whether the correct font. Okay? So I'm kind of easygoing, but I'm not, you know. It's just, some of that stuff does not meet this assignment. So for the discussion, use sources and cite something. This one is strange, but I've had people do the auto accident ones. Do not do auto accident questions. Not at all. Okay. We're going to ask open-ended questions and demand information. I suppose, yeah. I guess I didn't realize that that was that way. That must have been preset. I didn't set it that way, but I basically, everything is Saturday for the discussion. For discussion, 2 posts, 1 or more sources. And then Sunday for the rest. This is a slip and fall case in a grocery store. So you should do something about slip and fall. You are from all states. You need to have an understanding of what constitutes a slip and fall case. It's not about somebody bashing somebody over the head with an intentional tort. It's somebody not being as careful as they should be, or possibly they were and we're going to lose. Okay? Possibly they did everything they could to prevent an accident and they weren't negligent. Things will still happen even when nobody's negligent. Or maybe the defendant or the plaintiff was negligent. We don't know for sure yet. Okay. So that's kind of an interrogatory example. Then the discussion, yes, you want to do this, but again, cite a portion of Paul's graph, but explain in your own words, not some legal blogger's words, okay? In my experience, nothing is learned by repeating what some expert lawyer already said, unless you also put some of your own thoughts into it. Basically, your thinking rules on that. you're going to learn something about proximate cause. You're going to learn something about breach of duty. But I want you to think about it on your own rather than just look at somebody else's wonderful explanation of it, and then try to compare notes with your classmates. That's basically what you're doing. Yeah, you can do that. Yeah, exactly. It often helps a person remember the basic rules. One of my best classes in law school, I disagreed with the teacher about everything. I did so politely, not, I didn't harangue the teacher, but it was interesting because I was the loudmouth in the class, other than the teacher maybe, but I would raise my hand and volunteer, and I didn't always call on me, but if he wanted a dissenting opinion, he could just call on me, and I dissented with everything, but I learned more in that class than any other, but I had to back it up with something from case law or from logic, but I never got in difficulty with that because the professor would use what I said as a nice contrast and say, well, this is Mr. Olson's point of view. Mr. Olson is out of date on this legal concept, but the case law says this, Mr. Olson says that, and then he'd explain it, and everybody benefited, I think, to some extent. So yeah, don't just go along, get along. You learn more if you're willing to disagree. Proximate result is, oh, I don't think we're going to learn all that. That's module 2, excuse me. That's as much as we are going to do right now. We're almost at the end. I'm going to have you put additional questions in the course messaging. Is that okay? So I'm going to have to close it off now, and thanks for visiting with me.